Hmm. Hi, everyone. I will give everyone a couple of minutes to join this webinar, but thank you everyone for joining us today. See. Yeah, I'll just wait a couple minutes for everyone to, um, hi Matt. Hey. Cool, everyone is coming in. Hi, everyone.
Hello.
All right. Oh my gosh, yeah, it's summer. What a nice summer it's been, at least here, weather-wise. All right. Let's see. Do you think we're about ready to start, Nina?
Yeah, let's go.
Okay, cool. All right, everyone. Happy Wednesday. Thank you for joining us on our webinar about freelance workers and labor law updates in California. We're super excited to be having this webinar. We think this topic is extremely relevant, and we hope that it will be helpful in providing some useful information for everyone, whether you are a company that hires a lot of freelancers or independent contractors, or you yourself are an independent contractor. Okay, so some housekeeping matters. We have reserved time at the end of the webinar for Q&A. If you do have any questions, feel free to submit them via the Q&A function down at the bottom, I think. It should be available to you. We will either type up a response to you real quick if we are, in the middle of presenting, or if it's at the end, we can just answer it live. But either way, there will be an answer. And then after the conclusion of this webinar, everyone should be receiving a link to the recording along with this PowerPoint presentation that we are presenting. Okay. Um, Introductions. Let's see. So, first is Nina Amiri, founder and principal of Amiri Law PC. Nina is a well-known and respected attorney with over 20 years of experience practicing law. Opening her law firm back in 2019, Nina has dedicated her practice to making sure creatives are protected as they embark on their journeys within the entertainment industry, bringing a practical perspective to the legal challenges freelancers face. Her experience helps clients understand current applicable laws and make sure that they are compliant, whether they are production companies or individual filmmakers, writers, and digital content creators. Next up is Caitlin Bradshaw, an associate at Amiri Law PC. Having grown up in a family with a deep passion for music and art, Caitlin developed her own passion in helping creatives and artists retain their rights to their works. It was this experience that led her to law school to become an entertainment attorney. Since starting at Amiri Law as a law clerk in 2022 and then an associate in 2024, Caitlin has been able to gain wide-ranging experience on numerous types of entertainment projects, supporting several productions and creative teams in aligning their hiring practices with California's labor regulations. Last and hopefully not least, it's me, Kyla. I'm also an associate at Amiri Law PC, with a passion for entertainment born from my love of art, literature, and music. As someone who is creative myself, I understand how important it is to enforce the rights that you have when negotiating and entering into agreements. That's why I'm especially passionate about empowering independent creatives to navigate existing laws with confidence by translating complex legal requirements into clear, actionable guidance. With that, I will let Nina take it away with why we are here.
Welcome, everybody. Being entertainment lawyers, there are always clients that um, ask us questions about labor laws. And while we're not employment lawyers, we do have to have familiarity with labor laws that affect our industry, which is the entertainment industry. Um, as media production continues to evolve, there have been changes in labor laws. You know, we've had to, talk to clients about staying compliant, changing contracts that they've used. And so we thought that it would be helpful if we took some time to do a webinar breaking down some of the most recent California laws affecting freelance workers. That way, our clients can move forward with clarity and confidence. So, a lot of people have heard about Assembly Bill AB5. It was rolled out in 2019, and it introduced a test that's used to classify whether someone is going to be treated as an independent contractor or an employee. It was met with quite a bit of backlash. Many folks were upset. They wanted to remain freelance workers. You probably heard a lot of controversy around Uber drivers. Well, guess what? It also affected our industry. The other rule is Assembly Bill AB 2257. This came out in 2020. And this came about in order to create some exemptions to AB5. And so it kind of opened up a little bit more flexibility. And so we're going to kind of walk through who are some of the exempt folks under Bill 2257. So again, it was AB5 was enacted in 2019. The purpose was to clarify and tighten the rules surrounding whether someone is an employee or an independent contractor. Traditionally, this was kind of the realm of the IRS. Um, and, at the heart of the test that is laid out in AB5, it's basically a three-prong assessment. Um, and it kind of applies not only under the labor code, but the unemployment insurance code and the Industrial Welfare Commission's code. So there are several agencies that were affected by the implementation of AB5. There is a very well-known case that first utilized and analyzed the test, the ABC test. You may have heard of a case called Dynamex Operations West v. Superior Court. So big surprise. Who are, the parties in it? Well, it was delivery drivers. Like I said, a lot of the controversy started out in the realm of Uber and Lyft drivers. So until 2004, the Dynamex case classified and compensated California drivers as employees. But then in 2004, Dynamex changed their worker status, made them all independent contractors, and obviously, this benefited the company, right? They didn't have to pay employment taxes, which are very expensive here in California. So they didn't have to give benefits, they didn't have to pay payroll taxes. Well, the delivery drivers continued to do the same work that they had been doing. And then Dynamex continued to treat them the same. They exercised the same amount of control. And kind of what happened was the drivers realized, wait a minute, this isn't really actually fair to us. And so they sued Dynamex and they said that you are violating California labor laws because we are actually employees. So in that case, the court ruled on how they were going to classify workers. And in that case, the analysis was in fact more favorable to the drivers. Okay, so we're going to kind of walk through the different factors. The ABC test, it assumes that a worker is an employee, and it basically holds that you're an independent contractor if unless the hiring entity can prove one of the following. Okay. Um, Autonomy. So if you have flexibility on when you can work, um, how you get your work done, that shows that you're not really under the direction of the company. And so that goes in favor of you being an independent contractor. The other factor is business scope. So, is the work done by the worker outside the usual scope of the employer's business? Very easy example of this is the work that we do as lawyers. A lot of companies bring us in, ask us to provide legal services. Well, we're not doing work that the company normally does. We're independent contractors. C, independent trade. Um, if the company that's being has their established business, well, like a law firm, I have a established business. If I'm rendering services for somebody, I'm not their employee because I have a business and I service other people. So that's kind of the way that they go about utilizing the ABC tests. Oh, these are always fun. Our pop quizzes. Um, so everybody chime in here. Chime in on the chat. Which of the following is not a requirement of the ABC test to determine independent contractor status?
Wait, Caitlin, I think we can actually launch a poll, which we have set up. Okay, cool. The poll has been launched. Vote on that and let's see if everyone has been paying
Just
regular
FYI,
attention.
we can't vote. The panelists can't vote, so there's
I
no
know they're like
cheating.
waiting for us to put in our vote to see. Modern times like cheating on polls.
Okay, looks like we have a lot of people that have answered, so let's share the results. Okay, so most people chose C, that the worker performs the work entirely at their own expense. Drum roll. Yes, you guys are all correct. The worker performing the work entirely at their own expense is not a requirement of the ABC test. Good job, guys. So a little bit more of the legal background at the state level, like Nina kind of mentioned earlier, there was obvious backlash over AB5 and the ABC test, especially in our industry. The strict prongs from these tests made it really difficult for workers to be classified as freelancers, which we all know is super common in entertainment. So California realized that we very quickly needed something beyond just AB5 to fill those gaps and allow those difficulties that were created by the ABC test to be addressed. And that is where AB 2257 and the Borello test come in.
All right. So, legal background, state level is AB 2257. Like Nina had mentioned before, this was enacted mainly because there was a lot of backlash for the initial AB5. It affected a lot of delivery drivers, Uber drivers, or just typical freelance workers that you would kind of expect. But then also, it affected a lot of people in the entertainment industry too, because as many of you are probably familiar with, everything is done kind of on the fly, quickly. You need someone to come in, do a quick job. You only need them for like a week, 2 weeks. It's not a typical employer-employee structure in the entertainment industry. So, to meet the rising concerns about AB5 and to clarify classification exemptions for a variety of professions, um, they they specified certain roles that would have a different test. And these roles were musicians, recording artists, writers, photographers, illustrators, various types of creative professional roles within the industry. That were carved out because of all the backlash and just because of how this entertainment industry works. The mechanism that they used, or like how these AB 20 or AB 2257 exemptions worked, is that these workers, the ones that are listed on screen, may be classified as freelancers um, if they meet the more flexible Borello test instead of the rigid ABC test. Okay, so we had talked about the ABC test earlier. This is now the Borello test. So it can get a little confusing, especially when we get into the weeds of like legal classification and then using case analysis. But for our main purposes here, just know that there's two cases in play. There's the ABC test and there's a Borello test. So the Borello case was established in SG Borello and Sons Inc. versus Department of Industrial Relations. Basically, a farm owner was penalized for failing to secure appropriate workers' compensation coverage for a group of harvesters that were coming in and working on his farm. He argued that it wasn't necessary for him to secure coverage because the harvesters were independent contractors, not employees. If they were employees to him, then yes, he would want to secure appropriate workers' compensation, insurance coverage, other benefits that employees are usually entitled to. But he was arguing, no, they're not employees. They're just independent contractors. They come in and do a job. They're not entitled to the benefits I typically give to employees. The California Supreme Court disagreed. They ruled that these harvesters were employees, which meant that the farm owner was actually required to secure workers' compensation coverage. We actually don't care too much about the outcome of the case. The main part that we want to focus on is the test that the court used to determine whether these harvesters were employees. And that's what is now known as the Borello test. So, the Borello test is a multi-factor test to determine worker classification. So, like I said earlier, it's one of the tests that can be applied to your situation or any other specific pattern. But the primary factor, and this goes for, I think, also the ABC test as well, is whether the employer, the hiring entity, has the right to control the manner and means of the work. Do they have a right to control how you are making the illustration, how you're using Photoshop, how you are driving to deliver these things, or the means, like what you're using to do everything? Additional factors, though, include, is the worker engaged in a distinct occupation or business? What is the level of skill required? Is this a job that anyone can do, or is this a job that the worker, had to have specific training in order to know how to do? Does the employer provide the necessary tools and equipment? Like, are you providing the premises, or are you also providing, like, use this software to do this work for me, use this hammer, I don't know, use these specific tools to do stuff. Also, the method of payment. Um, take a look at like how employees are paid. They're usually paid on a set schedule, whether it's every 2 weeks, every week, but they're usually paid, a specific amount every 2 weeks or so. And then take a look at some independent contractors who get paid just a lump sum, whether at the end or maybe split in half, 50-50 at the commencement of services or at the end. So courts will take a look at how they are paid to see if they're treated as an independent contractor versus an employee. Is the work part of a regular part of the employer's business? If they're doing work that just adds to your business, like if you are, for example, a jewelry store and you hire someone to freelance as a cashier for your jewelry store, that leans more towards employee than bringing someone on to like fix your AC. That's not really part of your scope of work as a jewelry store. Um, Also, the degree of permanence of the working relationship. How long are they going to be working for you? And also whether there's an expectation of continuing service. If there is, leans towards employee, but if this is just kind of like a one and done situation, leans towards independent contractor. Okay. Oh, this is still me. Okay, so you have AB 2257 and then the Borello test. The Borello test is considered nicer than the AB5 test because it requires a consideration of all relevant facts to determine is this person an employee or is this person an independent contractor? Because of this flexibility, it's much easier for workers to be classified as independent contractors because, again, it looks at everything as a whole. It doesn't say, like, oh, you lose out on one factor, you're done. No, it looks at the entire, it takes a holistic view of everything. And certain things could weigh more than others, but with AB 22 or 2257, many in the in the entertainment industry have been able to preserve their status as freelancers, which is good if they want to be. Another big thing about AB 2257 is that it also clarified AB5's business to business exemption, making it much easier for small businesses or solo entrepreneurs like loan out companies, which I'm sure you've had experience with or that you have, to work together without triggering employee classification. Um, Loan out companies are a common practice in entertainment industry. Whenever we have clients that want to enter into agreements as individuals, we usually caution them not to and set up a loan out entity to protect their personal assets. This is pretty common practice. So AB 2257 is a huge part of the industry's legal landscape because of the business to business exemption that it affords. Pop quiz. What is one of the primary changes introduced by AB 2257 regarding worker classification? Oh, cool. Beautiful. Good timing. I'm sorry, I know I rambled. That was a lot of information. But thank you everyone for tuning in. Okay.
Oh, we're getting a couple of different mixed answers, so we'll give it another few seconds.
Why this is all so confusing, right?
Okay, hopefully we've got all the answers in. And there we go.
Oh, there's a split, kind of, sort of. It's B. Yep. So AB 2257 expanded exemptions for certain creative and entertainment professionals, allowing them to be classified using the more flexible Borello test. I think someone had answered C, it required all workers in California to be classified as employees. Um, that's not necessarily true, but I can see how someone would think that because that's kind of what AB5 did. AB5 leverages or uses a presumption that everyone is an employee unless proven otherwise using the AB5 test. But under this one, it just expanded exemptions and saying like, oh, these people, we can use a more flexible test. Let's not use the more strict one. But yeah.
All right. So another really important part where this factors into entertainment is the work made for hire clause. So most people in our industry are probably familiar with this clause. It essentially says that any work that this person does that you're contracting with is considered a work made for hire, meaning that the person that is hiring them will be the author and owner of the copyright for copyright purposes. So this is huge in intellectual property and in entertainment. Um, this was also affected by AB5 and AB 2257. So now, under certain California laws, work made for hire contract clauses can actually create a presumption that the person that is performing the work is now a statutory employee rather than an independent contractor. This can be the case even if in the contract it says this person is an independent contractor. They are rendering services as an independent contractor. The law essentially says that you can't waive this provision, and that even if the contract says something to the contrary, this person can still be considered as a statutory employee. What this would mean is the statutory employee would be entitled to certain employee benefits like workers' compensation, disability insurance, paid family leave, etc. So when these work made for hire clauses are included in an agreement with an independent contractor, the hiring entity has to be very careful and very specific. Otherwise, they could potentially be exposed to liability, employment costs, maybe penalties, back taxes, etc. There are quite a few risks now in including works made for hire clauses. So we have kind of strayed away from doing this in most of our agreements, and instead we've started opting for a more almost structured like an assignment provision instead, which will assign all of the IP rights in the work that they created to the hiring entity. That way you still get the rights, but you don't have to worry about the possible employment issues. So another important consideration at the federal level is everyone's favorite entity, the IRS. The IRS also has their own method for worker classification, and this can open up hiring entities to liability or responsibilities obligations at the federal level. So the IRS mainly looks at the following three categories to assess worker classification. They look at behavior, financial, and type of relationship. So under behavior, they look at whether the employer has the right to control what this worker is doing and how they do their job. That's very similar to what we see in the ABC test as well. Under financial, they look to whether or not the employer controls all of the financial aspects of that worker's job. You can think of certain things like reimbursements, providing tools, equipment, making sure they use company cars, things like that. All of those kind of fall under that financial category. And then the type of relationship. So they look at the overall relationship as a whole, and they look to see whether this relationship seems to indicate a regular employer-employee relationship in the amount that, the amount of control that they're exerting, things like that. The IRS does look at all factors relevant to each category, and they do weigh them all. So no one single factor or category is determinative. So it's important to try to make sure that, as an employer, you are following the rules of all of these categories and all of the factors. So even though a lot of these things are similar to the ABC test, it's not exactly the same there are a lot of similarities between how the IRS approaches this and the Borello test that Kyla kind of touched on earlier. The Borello test can be used to help you identify factors that might be relevant in assessing each type of category. Some of the things that they look at specifically from the IRS are whether workers hire their own employees, whether the work is done under like specific direction or supervision from the employer. Under financial, they look at, like we said, equipment, how they're being paid, whether the independent contractor has invested in the employer's business, and what the worker's opportunity is for profit or loss in taking on this job. In the type of relationship, they look to things like permanence of the working relationship. Is this a contract by contract basis, or is it, you've been working for us for 10 years now? Those are different types of factors that they may look at, including whether there's an expectation of continuing service beyond the term of an agreement. A huge thing that we see across all of the tests, and state and federal level, is whether the work being performed is a regular part of the employer's business. That is a huge indication that this is actually an employee who's performing regular work that's done in the course of the employer's business, rather than an independent contractor who does their own business and offers their own services and is more of a vendor relationship. So we're doing all of these, factors. We're looking at all these different classifications, and what is the overall importance other than like frustrating the IRS? If you independently classify, or if you incorrectly classify an employee as an independent contractor, you can face pretty severe penalties, both at the state and the federal level. So some of the penalties can include money damages per violation. If it's a willful misclassification, so you did it on purpose, that can go up to $25,000, and that's per violation. So if you repeatedly have these violations, that's just going to keep climbing up. It could, at the state level, be considered a violation of the labor code. That can bring penalties for unpaid wages or no paid overtime or missed benefits. It can also land you in a little bit of hot water with the EDD. So the EDD will assess liability on failure to pay taxes like unemployment and disability. As the employer, you are responsible for paying those for employees. So if you don't do that, the EDD will come after you, and you may have additional penalties on top of that, including but not limited to possible interest on top of all of the unpaid taxes. So California will get its due. It could also be a potential violation of workers' compensation laws as well. So with a lot of independent contractors, they don't have workers' compensation coverage. So you could end up in some hot water and being fined for each uninsured worker that becomes injured if they were incorrectly classified. You could also be liable for their medical costs, civil penalties. The worker can pursue you in court to pay for their medical damages, things like that. At the federal level, the IRS charges their own set of fines for unfiled W-2s. They will also add penalties and possible interest on the federal income taxes that were not properly withheld. They can take, some of what the employee should have been paying into for Social Security and Medicare. That may have to come out of your pocket. They may charge you back taxes. And there's just a straight penalty of 0.5% per month. So every month that you go without paying these taxes, they're going to continue to add just a straight penalty on top of all the other problems.
Well, I'm not sure if all of you know this, but my actual career as a lawyer started out in tax controversy. So I represented folks that were audited by the IRS for various things, misclassifying employees being one of them. Um, and you've seen what the fines are. But I think it's also important to just talk about the impact on your life. The IRS can collect taxes by filing a lien. Um, Attaches to your social security number, so it affects it. The lien attaches real property. They can levy your amounts. I had one client whose bank account got cleaned out by the IRS. That which was his fault because he kept ignoring letters and notices from them. But the reason I'm saying this is because the impact is real. Looking at legal cases and whatnot is one thing, but the actual impact, it can ruin someone's credit, it can destroy their business. So I just wanted to kind of just get it back to real life. What's new? Let's talk about what's new. So, though AB 2257 has helped to clarify who's classified as a freelancer, unfortunately, it didn't resolve big question about the protection of freelancers. So, um, just last year, September 2024, the Freelance Workers Protection Act was passed, and it officially went into effect this year, January 1st, 2025. The FWPA applies to all freelance contracts entered into or renewed on or after January 1st, 2025. It addresses the following methods of action. So, written contract. Number two, timely. Number three, prohibited practices. Number four, anti-retaliation. Number five, non-waivable. And number six, legal action.
Okay, so like Nina listed out, there are several built-in protections that freelance workers now have, and one of the most important ones is having a written contract. So written contracts are now required for services with a value of over 250, or sorry, 250 or more, either to be performed all at one time or over a period of 120 days. As the hiring party, if you are a production services company or even just an individual hiring another freelancer, you have to provide the contract, and a signed copy, physical or electronic, must be given to the independent contractor. This contract has to include the name and address of both parties, an itemized list of services. What exactly are you asking them to perform, or provide or render, the value of the services, and the compensation method to be used, whether it's check, Venmo, Wire, ACH, etc. You also need to include the payment deadlines or a method for determining when payment is due. So if you have already negotiated a set schedule, great, you can drop that schedule into the agreement, or you can say, uh, no later than 3 business days after the completion of all services, or no later than a set, just a way to determine, okay, this is when payment will be due. And then finally, a deadline for the freelancer to submit a list of the services rendered per the agreement, to meet the hiring party's internal processing deadlines for timely payment. So basically, this written contract endeavors to set expectations early on so there is no dispute later on. Important notes. As a hiring party, you need to have this contract for at least 4 years. You can't just toss it out after it's signed. You should still have it for at least 4 years. But the FWPA does not apply to contracts with government entities, foreign governments, or hires for personal, family, or household services. So that's an important note. The additional protections, we'll quickly go through them. Timely payment. If no payment date is specified, you still have to pay within 30 days of completion of the contracted service. Prohibited practices. Hiring parties can't require freelancers to accept less than what was already discussed or in the agreement, or suddenly demand additional services or like IP rights as a condition of receiving that timely payment. The FWPA does not allow that to happen. Freelancers are also now protected against retaliation. They have a right to exercise their rights and shouldn't be retaliated against for exercising rights that they are now entitled to. And lastly, no provision of the FWPA can be waived. Any attempted waiver, it's not going to work. It will still remain in effect no matter what the agreement actually says or what the parties agree to.
So under the FWPA, like Kyla said, there can be legal action. So in the event a freelancer's rights under the FWPA have been violated, they can bring a civil action against the hiring party. If the freelancer does win that lawsuit, they can be entitled to injunctive relief, which means basically preventing you from, continuing to misclassify them or continuing to engage in the violations that you are. And they could be entitled to attorney's fees and costs, straight monetary damages, and any other remedies that the court determines is appropriate. So this is really important because it is kind of in the court's discretion, and they do have a bit of a broad discretion on what types of remedies they can afford for violations of the FWPA. In some cases, if it's egregious, the freelancer may also be entitled to double the amount of unpaid compensation for delayed or withheld payments. So if the payments are unnecessarily delayed or prolonged or just not paid out at all or withheld for a reason that is not valid, the freelancer could be entitled to double the amount of their unpaid compensation, which is a pretty significant penalty. So it's really, really crucial to ensure compliance with all FWPA regulations. So another pop quiz. Under the FWPA, a freelancing contract must be in writing if the value of services is equal to or greater than what?
Give this one harder. Come on.
We probably could have made this one harder. A lot of
Yeah.
people answered pretty quickly.
Yeah.
Okay,
That means it'll stick in their head. That means they'll always remember this and never forget.
that is true. So, winner by a very, very small margin. $250 is the threshold that for which a contract has to be in writing. Good job, guys. So continuing on with the industry impact of the FWPA. So obviously this goes to protect freelancers. It is the Freelancer Worker Protection Act, but it also uniquely impacts the entertainment industry in a variety of ways. So we're going to break down kind of contract regulation, budgeting and scheduling, and specifically influencer deals.
So, under the blah, blah. I hate this like acronym. I can never say it. FWPA, Industry Impact on Contract Regulation. There's now a higher standard for contracting freelance work, which can add pressure to freelancers and their hiring party if they don't have counsel to kind of guide them through what are their rights, what does everything mean. But even if a hiring party refuses to provide a written contract, the that word can still protect freelancers. Other communications like text or email messages that summarize the agreement, summarize the services they're going to provide, summarize the amount of pay that you're going to get, can still be used to enforce freelancer rights. But this all goes back to you should have an agreement. It's important for both freelancers and the hiring parties. Hiring parties more so, because these are intended to protect freelancers, but in general, it's good to have a written agreement. Budgeting and scheduling. So, like Caitlin said, payment can't be delayed indefinitely, just because a payment schedule wasn't discussed. Like I mentioned before, you should have a schedule, or even if you don't have a schedule, find a way or establish a way to figure out when they are due their compensation. They can't be made to accept less than what was already agreed to. So hiring parties should make sure that they have the budget to pay, and then they can also pay on time. Um, Importantly, the FWPA now also applies to influencers who are considered freelancers under AB 5 or AB 2257. If you are a brand and you are working with an influencer, asking them to create dedicated TikToks or Instagram posts or just stuff to promote your brand, you should be careful, or a brand should be careful to assess whether the influencer falls within the freelancer classification to ensure that all applicable regulations are met. And then this is incorporating everything that we've already discussed before, like which test applies to them, what services are they rendering, and then make sure that they are properly accounted for in how much you're paying them, when you are paying them, etc. I think this is our last pop quiz. Which one of the following is not required to be included in a written freelancing contract under the FWPA?
So we do not have a
Oh,
poll for
cool.
this one. So if you guys just want to drop your answers in the chat, we can go from there.
We are good at law. We are not so good at technology.
It does get the better of us sometimes.
We're trying our best.
All right, we're seeing a couple of answers saying D.
All right, what is it?
It is D. So it's actually not required. Which, like someone pointed out, does seem odd, but the FWPA does not extend to that. But if you do want, that is an important consideration, especially in the entertainment industry. So if you do need help figuring out, okay, how do I account for ownership and licensing rights? You should have a written contract that's properly negotiated that reflects everyone's interests going into the agreement. And we can help with those. Yeah.
So let's get to why probably most of you are here, the compliance tips. So the best way to ensure compliance with changing laws is always to, consult an expert. We are experienced with these type of labor laws. It's one of the reasons we wanted to do this webinar and, help spread the information. We handle a lot of these types of agreements, and we are always happy to teach and educate and inform our clients about the updated requirements. We can help you determine the correct worker classification in order to help avoid any state or federal penalties. Since it does get very confusing and complicated, we would always recommend, even if it's not us, to consult with an expert that can help you on these worker classifications, especially considering the high penalties that you may face. Some of the things that we look to and that we would recommend you guys consider is things like avoiding contracting burden. The FWPA, like we said, does require more agreements to be memorialized in the form of a written contract. So that can create a burden on unprepared hiring parties. When you work with someone who's experienced in it, they can help avoid that burden and they can streamline the process. We always recommend that you review existing contracts. The FWPA applies to contracts that were entered before January 1st, 2025 as well, and have since been renewed. So if you have an older contract that has now been renewed and you have this independent contractor or freelancer in there, you want to make sure that you review those freelancing agreements and make sure that you are adhering to all of the FWPA requirements. Another good kind of audit process you can do is to review your payment process. Review your internal payment processing procedures, make sure that the payment for freelancing services is completed on time. Like we said, you don't want to worry about any penalties for missed or delayed payments. In future contracts, make sure that you're carefully scheduling the services according to budgetary needs so that you don't run into a situation where you can't pay the freelancer. Another good thing you can do is to review the retention process. So you can review your internal contract retention process and ensure that these contracts are effectively retained. Make sure that you can meet the FWPA's mandatory period of at least 4 years. So you do have to keep them in your files for a minimum of 4 years. So make sure that your internal processes and procedures have that stated and that everyone who's responsible for maintaining these contracts is aware of that requirement and upholds it. Another thing you can do is to go through and assess your classifications. The FWPA only applies to workers who are classified as freelancers. So always be sure to take into account all of the different factors that we've gone over, all of the ones that are laid out in the applicable laws, and carefully evaluate whether this worker should be considered a freelancer or an employee. Whenever you're not sure, like we said, it's best to just consult help from someone who knows how to go through those classifications with you. So now we do have a few minutes for Q&A. Let's see. So for Jill's question, what if you are working a gig, one single job, you probably won't work for that brand again and they want to pay you with a W-2, can you request a 1099? So this will depend on the factors surrounding your specific employment structure with them. Those work made for hire clauses can come into play. They may want to pay you with a W-2 just to make sure that they don't accidentally misclassify you or have, any liability for violations. So it will kind of depend more on the specific situations and the factors that go into your specific relationship with that employer. But generally speaking, these laws can't be waived. So even if you request a 1099, it doesn't cover the employer. So it wouldn't be a guarantee that they wouldn't run into violations. They may not be okay with it.
The next question, parties enter into a contract with a clause stating that even if the law considers the freelancer that freelancer personally wishes to be recognized as an independent contractor for a specific assignment. The goal is to ensure this understanding helps prevent future disputes regarding employment status, especially if the freelancer decides they want to have their cake and eat it too. Plain and simple, no, you can't circumvent the law. The law is the law. This is why we're sharing this information with you. We have seen contracts where people have tried to do this. It doesn't fly. And it's not, there's no way around it, unfortunately. It is what it is.
I think first there was a first part to that question that says if it's agreed upon by both parties that payment is net 60, does that mean that net 60 is waived in favor of net 30? So the net 30 only kicks in if there is no specified due date in the agreement. So if in the agreement you specify they'll be paid net 45 or net 60 after completion of services, that's when they will get paid. That's the time that both of you have agreed to. If for some reason the agreement does not say when they will get paid, then the statute or the AB, or sorry, the FWPA kicks in, and then they need to be paid within 30 days of completion of services. I think we have one more question. We have two questions. Who wants to take which?
So I can answer Melanie's. If you do have an existing work made for hire agreement, there may be amendments that you can make, but we would generally recommend to at least have it reviewed. It could be easier depending on what is in the work made for hire agreement to just kind of start over with an actual like freelance worker contract. So it really just depends on the specifics that are in there. Um, I think if you amended it and everybody signs, that would likely be enough to satisfy the written contract rule under the FWPA. But you would just have to make sure that it adheres to those strict requirements and standards. So I would be careful with amending previous contracts if they weren't originally built to comply with the FWPA.
Brad asks, in a call sheet and creative direction, are those considered control? For instance, if you hire a freelance gaffer and tell them to show up to a set at a specific time and tell them to how to light, would they be considered an employee then? Again, this is a multi-factor test. So one, uh, you know, piece of how the relationship was working isn't necessarily going to favor independent contractor or employee. But I would say that if somebody is not a job independently on their own time, that's a sign employee. That's like a very general, broad statement. Matt asks, if my project is ongoing throughout the year, do I need a contract for each shoot day if my people are paid daily? Um, I can't. It's the same. If it's the same show, um, you don't necessarily need a new contract, but you need to clearly outline what their rate is, what their responsibilities are. Um, I would imagine if something is ongoing, that does kind of lean more towards employee than independent contractor.
Yeah, there is a factor, just so you know, where like ongoing and repeated gigs that are kind of the same or for the same employer generally lends itself to an employee classification. So I would be careful with that one.
All right, everybody. Thank you guys so much for attending today. If you want more information, um, please reach out to us. Here's our contact information. We are going to be sending the slides to everyone that attended today. Um, and we are getting into the habit of posting our webinars on YouTube. Not sure exactly when that's going to happen. But if you have a friend or colleague that you think would benefit from this information, please share. And we look forward to hosting another webinar. We try to do these every other month, so stay in touch with us and we will send you the details. Thanks, everybody.
Thank you.
Bye.